Good afternoon. It's my privilege to welcome you to the William Stewart Memorial Lecture for Labor and Employment Law. Established in 2006, this lecture honors the late Bill Stewart, who is one of our most distinguished graduates. A veteran of the United States Army, he earned his JD here in 1959. 40 years later, he was inducted into the school's Academy of Law Alumni Fellows, the highest and most distinguished honor the school can bestow on one of our graduates. Bill Stewart was a scholar, an expert litigator, and a trailblazer in many ways. He was known for the highest levels of professionalism and exemplified how public service can be a high and noble calling. For 34 years, he was a lawyer for the National Labor Relations Board, and he was the board's first African-American chief counsel. His leadership and commitment to excellence prompted President Bill Clinton to award him the President's Award for Distinguished Federal Civilian Service and characterized his contributions to the NLRB as unparalleled. At the time, he was the first and only NLRB employee in its entire 69-year history to receive this honor, the highest honor that any civil servant can receive. Past Stewart lecturers have included William B. Gold from Stanford University, former NLRB chairman Laura J. Cooper, former NLRB chairman Laura J. Cooper from the University of Minnesota, and Martin Malin from the Chicago-Kent College of Law. Today, I'm very pleased to add to that long list of distinguished lecturers and to honor William Stewart's legacy by introducing Matthew Finkin, one of the nation's leading labor law scholars, as this year's Stewart Lecturer. Professor Finkin is the Albert J. Harno and Edward W. Cleary Chair in Law and the Director of the Program in Comparative Labor and Employment Law and Policy at the University of Illinois College of Law. He is also a faculty member in the School of Labor and Employment Relations. Professor Finkin has published countless influential law review articles, is the author of 9 influential books published by some of the nation's most prestigious university presses. He has the distinction of sitting on the editorial board of several journals in the United States and abroad. With the late Archibald Cox, Derek Bach, and Robert Gorman, he is the co-author of the preeminent and leading labor law casebook in the country. Professor Finkin has been active in the American Association of University Professors. He's served on numerous committees and as its general counsel. He's also a labor arbitrator and a fellow of the College of Labor and Employment Lawyers. Honors bestowed upon him include way too many for me to mention, but honorary doctorates at the universities in Germany and Greece. He was also awarded a University of Illinois Center for Advanced Study professorship, as well as an Alexander von Humboldt Foundation Research Prize. He's taught in law schools of Southern Methodist University, Duke University, and the University of Michigan. He has been a Fulbright professor at Munster University and a German Marshall Fund lecturer at Konstanz University. In other words, like William Stewart, Matthew Finkin is not only one of the leading thinkers who has left his mark in this field, but is a role model to those who practice and write in the area in labor and employment law. On behalf of the entire Maurer Law School community, please join me in warmly welcoming Professor Finkin.
Thank you, Dean Parrish. It's always humbling when an honest man exaggerates. I didn't know William Stewart, and from the account we've just been given, I regret that I never did make his acquaintance. I hope that what I have to say will honor this lecture series. I will confess to you all that I am technologically challenged. As you can tell from the gray, I do not own a computer. I don't like to be in the same room with a computer. But to keep the conversation going, I thought it might be useful to have some visual aids. May we have the first slide? There we are. The subject I want to discuss with you today is wage theft. Wage theft refers to employer practices that result in employees taking home less than they're legally entitled to under federal and state law. Paying below the minimum wage, not paying for time worked by having workers work off the clock before checking in, after checking out, or working unpaid break time, not paying for overtime at the overtime rate, or just not paying them at all. In popular culture, I think our image is of fly-by-night enterprises that lack a business address, that pick up undocumented workers on a street corner and have them do some residential reconstruction, and it's a minor problem that really should not engage us. But more recent research suggests that that simply is not the case. The photograph you have is taken from the New York Times of November. It's a photograph of a woman named Pinju Zheng. You'll notice that she is looking at a poster from the Labor Department informing her of her Fair Labor Standards rights, and it is in Chinese. She works at a Chinese restaurant in New York. She works 69 hours a week, and she's paid $5 an hour. When she complained to the New York State Labor Department, they informed her that the backlog of complaints was 14,000. Their procedure for handling a complaint is initially to make a telephone call to the company, and that she could expect them to get round to her case in about a year. That's not an unusual scenario. You see, I do have some statistics. I know your eyes glaze over. May we have the next slide? David Weil, who's recently been appointed with the consent of the Senate as the Wage and Hour Administrator of the Labor Department, a student of this problem, has written numerous studies. He was at Harvard and I think Boston University before that. This is a chart taken from one, he did in 2010, he did a really massive report, a kind of blueprint on what the Labor Department might be able to do. He's now in charge of it, and we'll see if the kinds of reforms that he had in mind will be able to be implemented. This chart is taken from that work, Improving Workplace Conditions Through Strategic Enforcement, it's called, and he called the complaints that the Labor Department had received that were disproportionate to the display of the workforce in terms of percentage of the composition of the workforce, and these are the employments which seem to be particularly prone to wage theft: eating and drinking, hotel, motel, janitorial services, health care, home care, groceries, and the like. A more finely tuned portrait was developed by Annette Bernhardt and her colleagues, showing that those most likely to be subject to wage theft tended more often to be female, 56% female, overwhelmingly minority, 97% black, Hispanic, or Asian. Contrary to most popular beliefs, 61% were either citizens or documented workers. The age distribution was fairly even, starting at quintiles from 18 to 25 to 46 plus. From the data on wage and hour violations, they found that 18.5% were in cleaning and maintenance, 16.5% in construction and installation, 16% in food preparation, 14% home health, 11% sales. Listing these industries aggregate to about 77% of such employments. Next slide, please. Annette Bernhardt, Michael Spiller, and Diana Polson have done work actually studying three markets where urban markets where wage theft is a common feature of the scene: New York, Los Angeles, and Chicago. They aggregated these data, and what it indicates are not only those who are at risk of violation on one column, but the survey of those who actually experienced an incident of wage theft or retaliation for having complained about it in the preceding week before the survey was taken. Extrapolating these data, they estimate that in any given week, 1.1 million workers are experiencing a wage violation. Inasmuch as the minimum wage violation came to $1.52, which is not an inconsequential sum for a worker at or on the cusp of the minimum wage. They estimate that in these cities, wage thefts amount to about $56 million a year in stolen wages. So, why is this happening? All of the students of the phenomenon conclude that this is a business model. Enforcement is weak, and we'll get to enforcement in a moment. If the employees tend to be smaller enterprises. The average complement of workers in the outlet is about 20. Franchises are more prone to wage theft than if the franchise owner, let's say if McDonald's runs the restaurant, it's much less likely to engage in wage theft than its franchisee. They tend overwhelmingly not to be unionized. It is extremely difficult to unionize these enterprises. The workers very often don't have the language skills, they don't have the education, they work very sporadic hours, they're hard to reach. The labor law makes it difficult for unions to reach them. There's very low union density, and we'll circle back to the role of unions as a means of addressing redress for wage theft. It's an attractive business model. These employees are happy to have a job at all. If they complain that wages are not being paid, they can be fired or given declined hours or otherwise life made miserable for them. They do not very often know that their legal rights are being violated, for that matter. If they are caught, the remedy of if the Labor Department, if a state or federal Labor Department gets a hold of them, then they just simply have to pay that which they would have paid anyway had they obeyed the law. So really, it's almost costless to the employer. The amazing thing to me as I look at these data is why more don't cheat. Next slide, please. The obvious address to this problem is in enforcement. This is a chart not quite randomly selected. I will explain why I picked these states. I've lost count. Is it about 13? Someone can give it a quick count, something like that? A scattering of states that indicate the number of labor inspectors. And for those that have a separate division of labor inspectors, the number of inspectors that are assigned specifically to wage theft problems. As you see, Indiana actually fares a little better. The average seems to be 1 inspector per million of population. There are as of 2010, there are 656.5 state labor inspectors for a civilian labor market of 130 million people. I haven't checked how many federal labor inspectors there are. The Obama administration did increase them, I think, to 2,500 or 35, something on that order. But again, you're talking about millions of workplaces and well over 100 million workers. Obviously, and the system is broken. It's something should be done. What might that be? There is a movement in law you may have followed called the New Governance Model, proposed extensive writing by Orly. I'm drawing. No. Orly Lobel at San Diego and Cindy Eslin at NYU about the internalizing the law as a value within it. And this work, one could look at Title VII, particularly in sex discrimination, and say that there's been a victory, that the companies have internalized the dictates of the law, in fact, have persuaded the courts that what they want to do is what the law requires. It's extremely hard to map that model on, and they've written about that. It's extremely hard to map that model onto a business model where why would you change the behavior of wage theft if that's the very nature of how you want to run the business? So we turn to the possibility of other private initiatives. The most obvious is unionization. Unions are entitled to information in the employer's possession that is relevant to the union's ability to bargain for wages, hours, and working conditions. So all the employees' time records and all that sort of thing have to be disclosed to the union. A union has a right to enter the workplace at a reasonable time and in a reasonable manner to assure that working conditions meet contractual or indeed public labor standards. They may bring or support legal action when need be. Unionized workplaces are much less prone to wage theft than are non-union workplaces. This would seem to be the obvious solution to the problem, would be to find means of encouraging the unionization of low-wage workers. But that's not going to happen. Right? Our labor law, to paraphrase, to quote Cindy Estlund, is ossified. It's extremely difficult. We make it extremely difficult for unions to secure a place. Recent events in Chattanooga we can talk about in the question and answer period. I was involved in that particular episode. So what else? Is there something else? Can I have the next slide? Can you read what's on the jacket of those people? Excuse me? Yes, ASPCA. One possibility that has been discussed is deputization. There are many states that deputize private organizations, humane organizations, and clothe them with public authority to inspect, in this case not people but horses, or other animals to make sure, livestock, to make sure they're properly fed and properly cared for medically and the like. Spiller and their group, Bernhardt and Spiller, discussed that as a possibility. They rather slough the legal aspects of it because they discussed this with the Labor Department, and the Labor Inspectorate in Washington and its union was absolutely and adamantly opposed. And I can understand why. You get a question of turf war, different priorities, different standards. You can prospect of deputized labor inspectors tripping over the public ones. But there's another problem, and that is if you deputize, and it's very, as I said, it's very common. I think almost every state has laws deputizing these humane officers that they become agents of the state, and they are as restrained by the Fourth Amendment as the public officer would be. They just can't walk in on somebody's property and the like. They have to either get a warrant, show probable cause, or a system. And there's also the possibility of a constitutional suit, a 1983 suit or the like, brought against them. The question of liability, we don't have to go there. It just bristles with legal problems. And it's not for both political and legal reasons. That is just not the way to go. Another possibility are, can we have the next slide, please? Yeah, would be zones of private action. The unions and the construction trades have negotiated to create funds with unionized employers. This is under the Labor Cooperation Act, and they can use that money to attempt to police non-union contractors to assure their adherence to labor standards. That's been done in California. It's possible to do that. It's perfectly lawful. This is an example. These are representatives of the International Transport Federation. The ITF, which is a global federation of transport unions, has its own standards for sailors. And these are ITF inspectors climbing on board a ship to see if this ship, whether or not it's a signatory of a collective agreement with one of its member unions. This is simply outside that whole framework. They're climbing onto the ship to make sure that these sailors are properly housed and fed and are being paid in a proper manner. Do they have any right to do that? No hands up? Remember, they're not an extension of any union that represents these people. In fact, there may be a sweetheart union, and the standards that union has negotiated is below the ITF standards. They're seeking to impose higher standards on this carrier. than the union that represents these sailors, or there may be no union that represents them at all, or it's a foreign union and it's lower standards than the international standard. No, how do they get on the ship? Well, the answer is they have no legal right to do it. The captain should, by all rights, grab him by the scruff of the neck and throw him into the sea. Why doesn't he? Well, what they'll do is they'll notify the stevedores that the ship is not in compliance with labor standards, and the stevedores won't unload the ship. Now, that's called a secondary boycott, and that's unlawful. But the ship is going to sit in port while we litigate over that, costing $50,000 to $100,000 a day. And so the captain lets them on. And we'll bargain with the ITF if they find violations. This is an area of self-help. But if you translate that into the American low-wage scene, for obvious reasons, that's not going to work. There have been discussions of public-private partnerships, particularly with worker centers. There are about 31 or 32 worker centers around the United States, mostly in urban areas. They cater to largely immigrant clientele. They're founded by churches, by immigrant groups, funded by some foundations. The unions have traditionally kept arm's length from these worker centers. They view them as competing centers of power, but more recently they've begun to cooperate with them, make common cause. They're founded by and participate by largely Mexican and Chinese immigrant groups. They speak the language, they develop the trust among those who are working, they will instruct them on their legal rights, help them file complaints. Bernhardt suggests that maybe that there are ways of partnering up as a kind of private initiative with these groups, but you'll notice it's a catch-as-catch-can proposition. Are there no other models? We have collective bargaining or nothing, right? You can't represent yourself. Under the Labor Act, you know, if you say I would like $1 an hour more, you can get fired for asking that. If you say we would like $1 an hour more, well, you can't get fired for that, but that's an artifact of our law. Is there nothing else? May I have the next? Now, I don't know that many of you will know who that is. Any guesses? No. Oh, how quickly they forget. That's Phil Murray. Phil Murray was vice president of the Mine Workers Union. He was John L. Lewis's right-hand man. In fact, when John Lewis created the Steelworkers Organizing Committee, the mine workers organized the steelworkers. He deputed Murray to be the president of the Steelworkers Organizing Committee, and he was the first president of the Steelworkers Union. I have to say, Ken would remember the late David Feller, who, as a young pup, told me once, going through his files, he found these stem-winding speeches he'd written for Phil Murray, you know, back in those days. Well, Murray testified in a case, the Guffey Coal Act, to rationalize the coal industry in the face of the Great Depression and the declaration of the unconstitutionality of the National Industrial Recovery Act. The Duffy Coal Act was passed by Congress and was challenged in the famous case, this you know from administrative law or constitutional law, of Carter Coal. And that law, too, was declared unconstitutional. But Phil Murray was a witness in that case. And I dug this out of a discussion of the Duffy Coal Act concerning the cross-examination of Phil Murray by the coal company's lawyer. Company's lawyer challengingly and persistently prodded Murray into giving at least one example. Well, let me take a step back. Where this is coming from. Have we no historical antecedents, no historical precedents of systematic wage cheating? The coal industry. Miners, in this period, we're talking about the late 19th, early 20th century, coal mining. The United States lived on coal. We were fueled by coal. And coal mining could be a highly skilled craft, could be. miners, skilled miners, insisted on being paid by the ton. So the coal had to be graded because there was slate in it, how much of it was real coal, and weighed. The size of the container of the varied. There was no standard coal bin, no trolley. It varied from company to company, indeed on the same premises. The volume of it, the weight varied. In fact, there was known as the miner's ton, which was 3,000 pounds, not 2. Right? And wage cheating was thought to be ubiquitous. Now to the examination of Phil Murray. The company's lawyer prodded him into giving at least one example. Give me one example, by name and date, of a case in which miners had been cheated through the false weighing of their coal. After some hesitation, Mr. Murray, in a low voice, must have been a very dramatic scene, told of a 16-year-old boy who, in 1903, had been deprived of 40% of the weight of his coal, of how he protested and was discharged, and how his father and entire family were immediately thrown out of the company-owned house into the street. Quote, "The name of the family evicted from their home without notice was Murray. The head of that family's name was William. His son was Philip. I am the individual involved." Next slide. The states that I listed in that chart were not, as I said, chosen at random. Universally throughout the coal field, all the coal field states in that period adopted check-weighman laws, including Indiana. This is the Indiana statute. It was not repealed until 1987. Some of the other states that were listed on that chart, their laws are still in effect. Illinois, Pennsylvania, in fact, West Virginia. The response made by these legislatures, Texas, Utah, was to allow the workers to elect, if they so chose, a check weighman. Next slide, please. This is Pennsylvania, early part of the 20th century. The man with the frock coat and the tie is the company check man, the weighman. The man looking at the ticket on the bin of coal is the employee's check weighman. Employees had a right, if they so chose, to elect at their own expense a check weighman. That check weighman had a right of access to the mine whenever the coal was being weighed, to check the weights, to make sure it was proper, to make sure that the employees were properly paid. And that was the provision of the Guffey Coal Act that Phil Murray was testifying about. I asked whether these old laws, some still on the books, would provide a new model, well, an old model, that we could revivify. Not for checking weight, but for checking wages. It is the employees who clothe the agent with power, not the state. They're not deputized by the state. Just as a union has a right, because its authority flows from the employees, to check their records, to make sure they're being properly paid, to visit the premises in non-work areas on non-work time in a non-disruptive manner. Okay? Well, there's a struggle over unionization, but why should there be a struggle over the right simply to pick not an agent to bargain for your wages, hours, and working conditions, but for your personal agent to make sure that you're being properly paid? Do these laws provide a template from which a modern wage checkman statute could be predicated? Well, what would it look like? What would we have to do? I want to talk a bit about legal feasibility, and then I I think we do have to address political feasibility. It seems to me the issues that a statute, most of these statutes, by the way, like Indiana's, were very, very short. The Colorado statute, the West Virginia statute did spend a little more time about how you're going to get elected and that sort of thing. Not much, a few sentences. These were very crisp, clean, and universally observed, by the way. I mean, there was not much litigation over it. Some employees, coal miners, didn't want a wage checkman. They knew it would be a union and they would have to pay union dues because the weighman is at their expense, not the company. But for the most part, the system, as best historically I've been able to determine, has worked pretty well. These laws fell into disuse not because of managerial resistance, but because of the change of the technology of mining coal. Coal miners were no longer paid by the ton. They were paid by the hour or the like. We mechanized the coal industry, and these weighmen checking the quality of your coal. You were paid on the basis of what your handiwork. It ceased to become a handiwork business. So what would what would a wage checkman statute have to be concerned about? One thing, of course, is eligibility. Who could be a wage checkman? I would think it is any entity, firm, partnership, you name it, so long as it's not dominated or controlled by the employer. Could that be a legal clinic at this law school? Why not? An accounting firm? A law firm? We got lots of young lawyers looking for jobs out there. Why not start a firm? Right? Or a union? Right? In fact, inasmuch as the administration of the statute should be given over to the hands of the state labor department, more on that in a moment, right? The state labor department could simply list acceptable petitioning organizations up front. We find these to be suitable, eligible wage checking entities. Legal clinic, law firm, union, fine. That seems to me the easy matter. The authority of the wage checkman. Again, I think that's straightforward. The checker should be entitled to the names, addresses, telephone numbers, cell phone numbers, contact information of the employees on whose behalf it functions. At its request, to copies of all records retained by the employer that contain information, or should contain information concerning the employer's wages and hours. Same information employers are commonly required to maintain and supply by law. The checker should be given authority to enter the premises, to inspect records, conduct inspections in a reasonable manner at a reasonable time. I'm just taking this right from National Labor Relations Authority. These kinds of access and informational rights have been available to unions now for decades. There's no reason why. They've not proven controversial in private employment. Why would they prove controversial in this, in this setting? And I could go on. The checker should provide, the law should provide the checkers authorized to seek information necessary to the enforcement of the act, and so on. Selection. I think that's one of the harder nuts, is selection. These laws anticipated that the miners would get together at the end of a shift. They're at the head of the mine and pick someone, usually a person. Schmidt, you want to be our, we picked Schmidt here. All vote, right? Done. There's no litigation, there's no Sturm und Drang over, the war for the hearts and minds of the miners over whether they will have a wage checker or who it would be. We have learned from bitter experience under the National Labor Relations Act that may be a Pollyanna-ish view, in as much as we would expect employers to be resistant. However, I do not think this is an area where I think the Labor Act is instructive here on what not to do. And that is, we do not want a highly juridified, contested election procedure, nor, I think, should that model apply. It doesn't need to apply. It is enough for a union to present to the state the list of those who've supported it, who've chosen it. It is enough for the state, at the request of the checking agency, but I'll say union for shorthand, to conduct an informal poll, even by telephone, and notify the employer that they are satisfied, the agency is satisfied as an administrative matter that the employees have chosen a checkman. And that's an unreviewable decision. It's an administrative decision. There's no requirement, I think, constitutionally that should be subject to any judicial review. It's any more than the employee or group of employees who decide to hire a lawyer to protect their rights. The employer has no say in that. There's no vote on it. The ministerial act of the state in informing the employer that it is satisfied that a checkman has been chosen, and that really should be the end of the matter. Now, I do, in this paper, go on at some length on the question of preemption. Would this scheme be preempted by the National Labor Relations Act? I think the answer is short. I'll cut to the chase because preemption is an extremely sophisticated and unnecessarily complicated doctrine, and the answer is no. We are not substituting a new system of collective bargaining for a state system of collective bargaining, for a federal system of collective bargaining. We're simply having the workers exercise a degree of agency to pick someone to monitor that adherence to law. By the way, a number of states provide that individuals shall have access to their own personnel files. And several of those states provide that the individual may select a representative who will have access to the individual's personnel files. And if you certify this is my representative, the company's got to let him look at your personnel file once a year in a manner that doesn't interfere with the business life. That doesn't upset any federal scheme. Next slide. Yes. The politics of the matter. Does anybody know who that is? Well, his name is Richard Berman. And I'm surprised you haven't recognized him. He's been in the New York Times. This is taken from the New York Times. And this is the March 10 Time magazine. There he is again. Mr. Berman has made a pretty good living. There's a photograph of his mansion in Virginia, his Bentley. He forms nonprofit organizations whose contributors can remain apparently anonymous. This is a tax matter. One of your tax people here. These are, but some of them are known, the Restaurant Association, they're business enterprises. It forms a nonprofit organization to advance the welfare of the business. They then retain Mr. Berman. He forms the foundation, is its president, and then hires his public relations firm to conduct the campaign on behalf of his client's interest. He was funded by Philip Morris to fight the movement to add no smoking sections to restaurants. He was president of the Beverage Retailers Against Drunk Driving, an organization formed to combat mothers against drunk driving, arguing for social tolerance of drinking. And as a consultant for the Minimum Wage Coalition to Save Jobs, this is, you may know that 600 economists have signed a petition supporting an increase in the minimum wage, including 7 Nobel Prize winners. This is a front page. This is from the New York Times. How much does this cost? Friday, February 27. Minimumwage.com. This is one of Berman's. And these are all the Marxists. These are to President Obama, 600 economists that you, and then here we go, Arthur McEwen, as Marxists we are committed. David Kotz, the particular model of socialism pioneered by the Soviet Union brought significant economic progress. Julie Mattei, Marxist, feminist, anti-racist ecological economist, self-described. In other words, this is all a femo-Marxist communist plot to raise the minimum wage. Now, that's the nature of American politics today. if one were, what is the political feasibility of simply taking an extant model? I didn't make this up. This is not coming from left. This is left field. This isn't, I'm not recreating the universe on paper here. I'm taking a statute that was adopted at the turn of the century in 13 states, including Kentucky, Tennessee, and adapting that model to its modern contemporary application for the same problem, wage theft. There is no doubt that this would be a, first of all, let's rule out the federal government. Nothing's going to happen in the federal government. We know, we needn't dwell on that. So we're talking about the state level. Well, we have this red state, blue state phenomenon. How likely is it that Indiana's going to revive its, okay, I'll stop there. But so what? What about Illinois? Democratic governor, Democratic House, Democratic Senate will probably retain that power. If the unions and the worker centers in the Chicago area say, we think that this is a good approach, and you'll notice, right? Or California, or some of the major jurisdictions. So we do have a red-blue divide, and you work with what God's given you, right? Why shouldn't this be an approach that would be attractive, at least in those jurisdictions? It's going to be one hell of a political fight, I understand. Not just by the wage cheaters. Why would mainstream businesses come to the aid? Why would the Chamber of Commerce come to the aid of bottom feeders, companies whose business model is, we're talking about stealing what somebody's owed. Right? Well, they're not supporting that. Well, they would see this for what it in part is, which is a portal of entry into these firms by unions. They can't be kept out. And once they've established credibility among these workers, okay, they're small units, 20 here, 20 there, but you can put them together. You can make comment, you can actually move to the next step, which is to offer yourself to the employees among whom you've built trust and confidence that they need collective representation. And there is, I think, some empirical evidence that the exercise of voice, the exercise of agency builds on itself. Those who had no experience of it don't, right? But once you get a taste for autonomy, a taste to be treated and regarded as a person, you want more. That's where the Bermans of the world will come in. Well, it may not be edifying in terms of the political exchange that we would witness if it got that far, but I think there's something healthy about putting wage and employee representation on the front burner on the political agenda of the United States, at least in certain, where that is feasible. We haven't talked about those issues. It comes up, it's creeping up in terms of minimum or wage inequality, fine, but we don't talk about representation. We don't talk about employee agency. And I find that glaring when you look at countries like Australia, not this election, in part this election, but the election before, the whole national campaign was about labor law. You take a look at Europe. I mean, what's burning? Is the financing of the welfare state and the flexibility or inflexibility of the labor market. In the United States, these issues, the labor issues, just seem to be disembodied. So I welcome the opportunity I think this approach would provide to get the issue of wage payment and of low-wage employee representation on the public agenda. Well, I see my time is, I've hit the 50 minutes, which is what professors always are used to, but I'll close on one observation on the utility of this proposal that I repeat, I don't think is will-o'-the-wisp because it's on the books in all these states. But the last time I was here at this distinguished institution, and let me say, if I didn't express my appreciation for the offer when my remarks opened, it was my oversight, and I expressed my very deep appreciation now. But what resonates in my head is the fact that this is my second appearance here. I was here a little over a decade ago when Kenneth Dow Schmidt was installed in the position he now holds. There was a wonderful symposium in his honor. I was very pleased and flattered to have been asked to participate and to give a paper, which was published in the Indiana Law Journal. And right before coming here, I had our library shepherdize that article, and I discovered that it was cited precisely once. And I looked it up. It was in a labor law journal by a professor at Georgetown who took issue with me. So before we go to questions and conclude this, let me express at least the personal aspiration that I have better luck this time than I had a decade ago. Thank you very much. Question? Yes.
Matt, with whether it's with weight checking or wage checking, the one thing I'm a little fuzzy on is where do the teeth come in? So, I mean, it's one thing to say, you know, hey, we're coming up a little short here, but assuming that sunshine and shaming, you know, don't lead the company to do what they're supposed to do, who can? So the people you're talking about are sort of blowing the whistle on the company, but then
I mean, in the modern form, this is my proposal.
well, or even with the weight checking, so it was one thing to say you'll have your own guy, but if it's coming up short, and he says it's coming up short, who forced the company to, you know, do something about it?
That's a terrific question. Why didn't I encounter that? I think one of the problems probably was that there was a dispute over whether the weights were right or wrong. And now that it was indisputable, I think self-help would be the logical thing. They just walk off the job because now they know their guy is certified. Okay. Right? Now, in terms of this proposal, I think the wage checker would have to develop a pretty good relationship with the federal and state inspectorate. They'd have to work in tandem. One thing we didn't talk about is the state inspector, the state labor department, is now doing something they've never done before, which is to certify a representative rather than, you know, go through a stack of complaints. Would they be willing to do that? Well, maybe there are state labor boards. I mean, I think, you know, if they see it to their benefit, if they see a payoff on their turf. Finally, the prospect of a lawsuit is, you know, if you have a law firm or a union that's collecting enough of these claims and can bring a class claim to which attorney fees apply, you know, and finally, I don't think we should minimize the deterrent effect. The prospect of getting a wage checker in there, it may change the business model. I gotta fly right, because otherwise someone's gonna be looking over my shoulder, and that someone may ripen into an honest-to-God union that I don't want to do. Yeah?
You mentioned minimum wage. I was looking around the world, and Australia's minimum wage is $16 an hour for adults. And it only costs them like 70 cents more than a Big Mac. They didn't go through a recession like the world did in 2008 because they had demand from their workers. With everything that I studied, you mentioned minimum wage, everything I studied, it appears to be the solution to so much, including our low union representation. Because when the minimum wage, if it would go up to $16, it would help everyone's wages, you know, all the way up. What we're missing in not having a unionized country.
No, I mean, no, Australia is interesting. They have this new Fair Work Australia. It's just, you know, 2009, no one knows what it means. Their system of representation is just sort of wonderful, right? You have, because anyone can represent himself. Yeah, you get to, I think that, you know, the economics, we've got an economist here, of minimum wage, 16 bucks an hour is out of the question for the United States. Politically, forget what the economics of it would be. But I think you're right in the sense that if one had a different chart that showed three things, productivity from 1970 to today, and I think you'd see more or less a straight line going up. Wages. Starting in 1973, it remains flat, basically. That's It's actually not true, because the top 10% is doing, the top quintile is doing okay, the top 1% is off the scale, the bottom 10% is down. So if you use an average figure, if you're including high school and college and so on, it's flat. And then union density, starting in 1973, is a straight line decline. And I think most economists, sensible economists, would agree that to some extent, the inequality, the failure to recapture the economic return from gains in productivity is due to a lack of union representation. I don't think there's, now, what percent and so on, we can argue about that, but I don't think anyone really disagrees that if there were greater union density, you'd see a greater capture. Look, after World War II, when union density was about 37%, there was a kind of social contract, unspoken contract. We will be more productive. We, the workers, will be more productive. You will find ways to make us more productive with mechanization, you name it. We will be more productive. You will be right? So your productivity will go up, and therefore your profits. We will recapture part of it. And so we built a blue-collar middle class, which is extraordinary phenomenon. Now that's gone. The compact is gone, because union density went from 37% to 6.6% in the private sector, 6.6%. It's the lowest in the developed world, except for maybe France, but but the French unions do. They seem to shut down the subways when tourists are in town.
Instead of increased wages, now they just borrow the money to us in loans and credit card debt.
Well, now you're getting off from what I'm working on, but it does interest that the economists are here. We have depressed interest rates, all right, to the point of almost zero. The banks, to inflate the banks, they're not lending the money except. So I'm amazed that we have not heard from the millions of retirees who depend on those savings as part of the tripod for your retirement, Social Security, right, savings and private pension. If you're lucky on a long-term CD to get what, 2% maybe? No, 1.7. I think Ally is offering 1.7. My retirement, right? So that the banks borrow it at below 1% and lend it at what, 18? And who's paying for that? It's these retirees, millions of retirees who can't. Their standard of living. I mean, this explains part of Japan's problem, right? I mean, they deflated the currency. They're trying to reinflate it. Japan is an aging society. It's got the largest cohort, right? And if you inflate your way out of the situation they're in, they have got millions and millions of retirees who are also voters saying our purchasing power is disappearing. That's the conundrum Japan is in, I think. We're in a reverse situation. I do understand that, but I don't understand this, for a tenured professor to complain about the passivity of the American working class comes with ill grace, right? But I don't understand it. People are getting so screwed. Look at pensions. We've shifted from guaranteed benefits to money purchase plans, right? We've flipped it. No one has a guaranteed benefit anymore. Where's the protest? I gave a talk in Seoul, Korea, on events that are at wages, particularly pension, and one of the members in the audience stood up, turned his back to me, which I grew up as a kid in Japan. I don't think that was a very polite thing to do. Mm-hmm. Took the microphone, the translator was being very polite. I said, basically, I don't know what this fool is trying to tell you. He obviously doesn't know what he's talking about, because if anything like that were happening in Korea, there would be riots in the streets. You'd see cars burning, and the riot police would be out. It would look like something from Apocalypse Now, and it's not happening. Right? So therefore, the riots aren't happening, so therefore, this isn't happening in America. And I had to tell him, well, maybe you know more about the United States than I do, but maybe American workers have not read Joe Sorel. They've read Henry David Thoreau, that most men lead lives of quiet desperation, happy to have any job on any terms. but I've faced this in Europe and in Asia. They ask me, where's the anger? Where are the protests? And I'm at a loss to explain. I'm just at a loss to explain. 1, 2, 3.
Yeah, one of the issues I'm having trouble seeing about the wage checker is that it seems that you've got a similar problem with, the basic unionizing problem. When you had the wage checker with these co-workers, they were all working at the same time to communicate and organize, but if only, if you've got retail shifts that are staggered and not regular, how are you going to get it so that employers don't have the ability to retaliate when someone says, hey, I've been appointed the wage checker? It seems like you would need a significant portion of the employee force in order to prevent them.
Yeah, and that's right, and that's the point I tried to make. The difficulty of getting one selected. Okay, when I say wage checker, I don't mean one of your coworkers. First of all, it is an anonymous process, and that makes a difference, I think. They can't figure out who it is who said I want, okay? You have the state, once the demand, an agency comes forward to the state and says, I want to check the wages at this Walmart. The state would then go to the Walmart and say, give us the names and addresses, the contact information for your workers. I conduct a telephone poll. Do you want to have a wage checker? And if the agency is, if the government, if the Labor Department is satisfied that these workers, all of whom work, no more than 32 hours a week, and they're, okay, staggered terms, we have, if it says to Walmart, SEIU has been chosen. SEIU has been chosen. They have a right, a statutory right. Okay. Now, they won't let him in, well, then they've got a litigation on their hands, right? I mean, but the litigation isn't over whether they pick this agent or not. Okay? So I think I do try to come to grips with that problem.
So he'd have access to the whole shop.
Sure, it is a system of majority rule. The majority of the employees working there have to be, well, I should say, the Labor Department has satisfied itself by means suitable to it that the majority of the employees in this office facility, whatever, desire to have this wage check. End of debate on that issue. 2.
Yeah. You sort of presented this model based on the coal industry. And one of the things that you talked about, and please correct me if I'm wrong, it sounded like you were saying that as coal became less of a skilled position, more of a non-skilled position, you don't.
No, they're no longer paid by the weight or the quality of the coal. You were paid by you became an hourly paid employee because the stuff was just being.
Well, but do they still grade the coal? I mean, like
you're not paid that. In fact, but the interesting thing that the West Virginia statute, because I think they had the problem of class legislation. Remember in the turn of the century, you can't have a law just for railroads. It has to be all corporations. So the West Virginia law, still on the books, says that any employee paid on a piece rate basis in any corporation has a right to have the piece rate checked. It's still in West Virginia law. Floored me. Right? So
well, but I think that we can still make this distinguish between somebody who's getting paid based on the hour and based on the amount. And I think a lot of the positions you're trying to apply this weight checker to are people that are being paid by the hour.
And we want to check their hours.
Okay.
Federal law requires that they keep accurate records, and we want to make sure the records are. I mean, what Walmart, there have been massive suits against Walmart for. You understand what Walmart, as I understand from Nelson Lichtenstein's book, right? A manager is told on a weekly basis, I think, out of Bentonville, this is your labor budget. This is the amount of money you have to spend. And this is what you have to get done. And don't violate Fair Labor Standards Act. Well, you can't. You can't get the work done with this labor budget. And by the way, no one could work more than 32 hours a week. Maybe 29 as a result of the Affordable Care Act. So what does the employer do? He says, okay, punch out, lock the door, stay for 15 minutes and mop the floor. Stay for 15 minutes and stock a shelf. That's only 15 minutes. All right. How many workers does Walmart have? 1.4 million. Right. Each being cheated out of 10 minutes a week. Well, you can do the math. They're talking millions and millions of dollars. Right? The checker is not checking the weight or the quality. He's checking you're being paid for the time you work. If it's your lunch break, you're not working through your lunch break. That's break time. If you worked 41 hours, you are entitled to an hour and a time and a half overtime. Right? That's what the wage checker does. Yeah?
Professor, you talk about the political realities of this and how a lot of the resistance is going to be to the potential effect that unions might have to raise this point. Do you think that a possible compromise that might make this more palatable in a wider area than the democratic struggles that you mentioned might be to exclude public unions from being eligible as wage checkers? So you said how there are lots of potential options for wage checkers, law firms, accounting firms, independent groups that aren't influenced by employers. So if we drew up this law to exclude public unions as potential wage checkers, perhaps that would eliminate some of the resistance that you are anticipating.
You got a constitutional problem with that? Freedom of association? The state's drawing a distinction between, unless, I mean, you could do it and say this is legal practice, this is the practice of law, which it isn't. Only law firms can do it. But once you say, I can't see how you can say you have a right of representation of anybody except a voluntary sodality that we call, what is a labor organization? An organization of any kind that exists in whole or in part to deal with employers over wages and work conditions in which employees participate. They use any kind. So that there goes your, I think your workers' center maybe. No, I don't see how you can draw that distinction. I really don't.
Could you perhaps make it, at least in a professional qualification that would make basically limit it to accounting firms
or the union supplies a lawyer, a staff lawyer. That's the union. Yeah.
So thank you for the thought-provoking presentation, in particular on the recommendation to use a check weighman. I wanted to suggest that your recommendation, I think, finds support in some of the social psychological literature, in particular research on procedural justice. And this may go towards this narrow sense of self-interest on the employer's part about cheating their way into additional profits. So this social psychological literature on procedural justice suggests that as you elevate levels of perceptions of procedural justice, this will increase the perceived legitimacy of employers, which will also have these downstream implications of pro-social workplace behavior, more productivity in the workplace, all these downstream benefits that seem entirely consistent with the kinds of behaviors that will that employers would value, right? And so the check weighman model, it seems to me, offers an opportunity for employees to collectively voice their concerns, an opportunity to be heard. They'll have a neutral and trustworthy person within the process, and they'll have these elevated feelings of being treated with dignity and respect. All of that, again, is consistent with these downstream implications that if you take a longer term view, I think employers would also value. So there's a sense of a potential win-win on that side as well.
If you care to join me on the article, I'd be welcome to. It's exactly the point I was trying to make, and you made it much more eloquently than I. That I think it's a step that will lead to that. I mean, America is, in some respects, putting aside the lack of enforcement of the wage and hour, we're sort of agnostic on the high-performance work, high-involvement workplace. You can pick a high road, you pick a low road. We don't care, and we think the market will sort that out. And so you've got these low-road employers. I do a lot of work in Germany. The German model is, a high-road model. You can be a low-road employer in Germany. It's very, very hard. They think this is the way to go. This is how you develop a workforce and so on. So if this law ever got passed somewhere or somewheres, maybe certain employers would say, I mean, there's work that's been done. Fast Food Nation has shown that, if you really screw workers, if they have any kind of opportunity, they quit. Right? We tend not to. The economists talk about training, recruitment, and training costs, but I've yet to talk to a manager, who speaks in those terms. Even a fast food worker, according to the last study, it costs $1,800 to train a fast food worker. Well, if you have lower turnover, that's a sort of unaccounted for saving. If you have a workforce that believes it's being well treated and is contented and remains, keeping those skills and improving the skills they have, you don't have to recruit, you don't have to train. It's a better path for employers. But a lot of employers don't see it that way, and this sort of rooting on the presence of the wage checker is one more nudge in the direction of choosing a high-performance work environment. We have time for...
Maybe one more. Is there one more?
There are more there. Sir.
I just had a question about implementation, and I like the model with the wage checker. It's open and obvious, and there's certainly some things in this context is on the books, they can see it. But aren't there also some things that are less obvious or off the books? And wouldn't that mean that either a possible shift by the employers to things that aren't as easily checked, or more extensive involvement by the checkers? Not just, in other words, standing at the one point, but literally almost following people through the day and much more extensive throughout the business.
Well, three things. First of all, and it's one of the minimum wage, but if the use of labor becomes more onerous, you might substitute capital, machinery. And those of you who may follow this stuff, Chili's restaurant chain is now instituting a tablet at the, this is what low-end casual dining is what they call it. Right? But it's not fast food. You sit down, and there's a screen where you pick your dish. The waiter doesn't come out and say, "I'm Dwayne, I'm your waiter tonight, and these are our specials." It's on the computer, and you can pay in the machine. So we reduce servers by, all they do is bring you what you ordered. You can reduce the number. So we're already witnessing the automation or mechanization of some of these industries, and that might be one consequence if it becomes more doable. Now, the idea that will a company become, or an employer become panoptic? They already are. Right? They already are. That gets us into the whole world of employee privacy, but the Labor Department has an app. Am I using that word? Look who you're talking to. For workers to track their hours. Yeah. Right? Because if the employer is not keeping records, it's a violation of federal law. But then how do you prove you worked the hours you claimed you worked and that the employer cheated you? Now we're equipping workers to monitor themselves to assure the accuracy of what the employer has done. But that's adventitious, right? I'm trying to give it a system, a structure. Again, thank you all very, very much.